Good morning and welcome to the Supreme Court of the United Kingdom. Today and tomorrow, an appeal by Her Majesty's Commissioners of Revenue and Customs from a judgment by the Court of Appeal of England and Wales. The case concerns the doctrine of estoppel by convention, and the question is whether the taxpayer, Mr. Tinkler, is barred from arguing that an inquiry into his tax affairs had not been initiated by statutory notice within the time allowed by the statute. The revenue are represented today by Malcolm Gammy QC, Michael Jones QC, and Nicholas Mack, and the taxpayer, Mr. Tinkler, is represented by Roger Thomas QC and Emma Pierce. I will now introduce the panel. I'm Lord Hodge, Deputy President of the Court, and sitting with me today are Lord Briggs.
Good morning.
Lady Arden.
Good morning.
Lord Burrows.
Good morning.
And Lady Rose.
Good morning.
I now invite Mr. Gammy to commence his submissions.
Thank you, my lord. Good morning, my lords, and good morning, my ladies. As my Lord Hodge said, I appear for Her Majesty's Revenue and Customs, together with my learned friends Michael Jones QC and Nicholas Macklem, and my learned friends Miss Roger Thomas QC and Miss Emma Pierce appear for the respondent, Mr. Tinkler. My lords, my ladies, you have our written case, which I will take as read and adopt as part of my submissions. The background and circumstances of this appeal are shortly stated. On the 1st of July 2005, Mr. Mackay, an officer of Her Majesty's Revenue and Customs, dealing with Mr. Tinkler's tax return for the tax year 2003-2004, wrote to Mr. Tinkler under Section 9A of the 1970 Taxes Management Act to notify him that he intended to inquire into Mr. Tinkler's return for that year. On the same day, Mr. Mackay wrote to Mr. Tinkler's agent, BDO Stoy Hayward, enclosing a copy of his inquiry letter to Mr. Tinkler. BDO acknowledged receipt of Mr. Mackay's inquiry letter on the 6th of July, and thereafter BDO engaged with the inquiry that was the subject of Mr. Mackay's letter of 1st of July 2005. 7 years later, in August 2012, the Revenue issued a closure notice. It denied Mr. Tinkler the benefit of a large loss that was said to arise from a gilt strip scheme into which he had entered. Mr. Tinkler appealed the closure notice, but in 2015, shortly before his appeal was due to be heard, he raised the issue that is currently before this court, namely whether the Revenue had ever validly opened an inquiry into his tax return for the year 2003-2004. I can briefly lay out where this litigation currently stands. Mr. Mackay addressed the inquiry letter to one of Mr. Tinkler's former residences. The Management Act does not require that notice should be sent to a specific address, just to the taxpayer. Had the letter been forwarded to Mr. Tinkler and received by him, we would not be here today. The first-tier tribunal concluded, however, that Mr. Tinkler never received the inquiry letter. BDO, his accountants, did receive the copy of the inquiry letter, but the Court of Appeal concluded that notification to BDO did not amount to giving notice to Mr. Tinkler because BDO had no authority to receive a statutory notice of inquiry on his behalf. The first-tier tribunal concluded that by November 2005, BDO had told Mr. Tinkler or his personal assistant, who ordinarily dealt with his tax affairs, about the existence of the inquiry. That was well within the time allowed for opening an inquiry, but the Revenue accepted that BDO's action in telling Mr. Tinkler or his PA did not amount to the giving of notice by the Revenue to Mr. Tinkler for the purposes of Section 9A of the Management Act. Nevertheless, the first-tier tribunal did conclude that BDO was acting on Mr. Tinkler's behalf in dealing with the Revenue's inquiries into Mr. Tinkler's tax return and corresponded with the Revenue on that basis. Accordingly, the short but important issue in this appeal is whether BDO's action in engaging on Mr. Tinkler's behalf with the subject matter of Mr. Mackay's letter of the 1st of July 2005 means that Mr. Tinkler is stopped by convention from resiling from a common assumption held by the parties that the Revenue had validly opened an inquiry into his return for the 2003-2004 tax year. The first-tier tribunal found in the Revenue's favour in respect of that issue, but the upper tribunal and the Court of Appeal disagreed. In our submission, there are two key questions that need to be addressed. First, whether Mr. Tinkler, acting by his agent, BDO, assumed the requisite element of responsibility for the common assumption between the parties that an inquiry had validly been opened. And second, whether it is unconscionable for Mr. Tinkler to be permitted to resile from that common assumption. In addition, Mr. Tinkler's case raises a number of other issues, which are summarised at paragraph 7 of his written case. You'll note that's in the bundle at page 100. I don't think you need to go to it now. But first, Mr. Tinkler asserts that this is not a case about convention estoppel at all. He asserts that the Revenue is seeking to convert an estoppel by representation, which Mr. Tinkler says he could have set up, into estoppel by convention. We do not understand that point particularly, and it's not developed elsewhere in Mr. Tinkler's written case. So I'll say no more about the way in which it's put in paragraph 7 until I've heard what my learned friend has to say in his oral submissions. But the written case, Mr. Tinkler also puts or suggests that there are two gateway points that he can take, on the basis of which he asserts one never even gets to considering the ingredients of convention estoppel on the facts of this case. They're summarised at paragraph 66 of his written case. Again, if you'll note, that's on page 121 in the bundle. The first is whether in the present case there was a transaction or course of mutual dealing between the parties in respect of which the assumption could form the conventional basis. The second is whether Section 9A of the 1970 Taxes Management Act effectively overrides or precludes the operation of the doctrine of conventional estoppel. Finally, Mr. Tinkler says that in any event, the Revenue have not discharged the burden of proving that any of the relevant criteria for convention estoppel are met. Now, I propose to structure my submissions in three parts. In the first part, I'll clear the ground of Mr. Tinkler's various complaints, which in our submission have no bearing on the points of law of general public importance with which this court is concerned. In part 2, I will briefly set out what is and what is not in dispute about the points of law in issue in this appeal. And then in part 3, I will advance our submissions on the points of law in issue in this appeal. So, turning to part 1, and really attempting to clear the ground and deal with some of the complaints that Mr. Tinkler makes in his written case. Much of his written case is devoted to complaints which are, in our respectful submission, have no bearing on the points of law of general public importance with which this court is concerned. They fall into three categories. First, Mr. Tinkler's written case advances a number of unwarranted criticisms about Mr. Mackay's conduct. It goes as far as describing his error in sending the inquiry letter to Mr. Tinkler's former residential address as an unjustified and improper act. These are not descriptions you will find in the decision of the fact-finding tribunal, and they are without foundation. The fact of the matter is that Mr. Mackay made a mistake, probably motivated by a desire to write to Mr. Tinkler at what he understood to be his residential address, rather than care of a business address. There's no more to it than that. Secondly, Mr. Tinkler's written case advances a number of complaints about how the estoppel argument was raised in the first-tier tribunal. As to this, I simply say that any such complaints ought to have been raised before the first-tier tribunal if they were going to be raised at all. No such complaint was made, and after two previous appeals, we're now beyond the point at which such complaints can be advanced. Thirdly, Mr. Tinkler's written case seeks to characterize two findings of fact made by the first-tier tribunal as being based on no evidence, as he puts it in the written case. First, the first-tier tribunal's finding that Mr. Tinkler and or his PA were informed of the inquiry by November 2005. Secondly, the first-tier tribunal's finding that but for the actions of BDO, the revenue would have taken different steps, which may well have remedied the position as regards the inquiry. As to these complaints, if Mr. Tinkler wished to pick apart the first-tier tribunal's factual findings, the time to do so was before the upper tribunal, not before the Supreme Court. In any event, the first-tier tribunal heard Mr. Tinkler's evidence and saw the correspondence. It was perfectly entitled to make the findings in question. In that respect, it did no more than what my Lord Briggs did in assessing the evidence in bench dollar, to which we will be looking and coming in more detail later. As regards the finding that Mr. Tinkler and or his personal assistant were informed of the inquiry by November 2005, this is a clear, logical and common sense finding. The assertion made on behalf of Mr. Tinkler in his written case amounts to saying that BDO, a respected professional firm, amended Mr. Tinkler's return and liaised with the revenue on Mr. Tinkler's inquiry without informing Mr. Tinkler or his PA even to ask for payment of their professional fees. That contention is unrealistic, but in any event, proposition that the first-tier tribunal was not entitled to reach that finding is, with respect, unsustainable. As regards the findings that, but for BDO responding as they did to the Revenue's letter of the 1st of July 2005, the Revenue would have taken steps to remedy the position as regards the inquiry. Again, I submit that that is a common sense finding made by the first fact-finding tribunal, which was perfectly open to it. As we have set out in our written case, paragraph 74, in bundle page 95, the hurdle that Mr. Tinkler must clear in order to upset those findings of fact is a very high one. His complaints about the findings I have mentioned do not even begin to meet that high threshold. The findings were ones that the first-tier tribunal was perfectly entitled to make and are not now open to challenge. That is all I propose to say about the complaints that Mr. Tinkler makes in his written case. No doubt my learned friend will have more to say, and I will respond as necessary in reply. So that takes me to part 2, what is and what is not in dispute. What is not in dispute in this appeal is that the ingredients for estoppel by convention are those summarised in Brindley Heath, which are themselves drawn from the judgments of my Lord Briggs in the bench dollar and Stena Line cases. They're set out in our written case at paragraph 17. It's not in dispute, and has never been in dispute, that the burden was on the revenue to satisfy the first tier tribunal if those ingredients are present in this case. What is in dispute is as follows. Mr. Tinkler argues, I think for the first time, that none of the Brindley ingredients are present. This appears at paragraph 41D of his written case. He argues that the revenue failed to establish that there was any common assumption, let alone one that crossed the line in a manner sufficient to manifest an assent to that assumption. As to that, the first tier tribunal found as a fact that there was a common assumption. That is the first tier tribunal's decision of paragraphs 146 to 147. That finding of fact has not been overturned. Indeed, the upper tribunal expressly agreed with it, stating in terms that it seems clear that there was such an assumption. That's the upper tribunal decision at paragraph 61. Likewise, the Court of Appeal took no issue with this aspect. So I say that this ingredient is present, and there are findings of fact to that effect which have not been overturned. Mr. Tinkler argues that the revenue failed to establish that Mr. Tinkler assumed some element of responsibility for the common assumption. That is one of the key issues to which I will be coming in more detail shortly. And then Mr. Tinkler also argues that the revenue failed to establish that they relied on that common assumption. As to that, again, the first tier tribunal found as a fact that the revenue relied on the common assumption. That is the first tier tribunal's decision of paragraphs 149, 150, 155 to 160, and at paragraph 162. That finding of fact has not been overturned, so I say that this ingredient is also present. And then Mr. Tinkler argues that the revenue failed to establish any detriment sufficient to make it unconscionable for Mr. Tinkler to assert the true position. I'll also address that issue in more detail later in my submissions. That is the second key issue after the question of whether or not there was an element of responsibility on Mr. Tinkler's part for the common assumption. So those are the essential issues that are agreed or not in dispute or in dispute, which brings me to part 3 of my submissions, which, as you may anticipate, will take a bit longer to work through. And the way I want to work through my submissions in part 3 is to deal first with Mr. Tinkler's 2 gateway points that I outlined a few minutes ago, and second, to deal with what I have described as the 2 key ingredients of assumption of responsibility and unconscionability. So dealing first with Mr. Tinkler's 2 gateway points. The first gateway condition, as he puts it, appears at paragraph 66 of his written case. That is in the bundle at page 121, if you wish to look at it. And he says there that there was no transaction or course of mutual dealing between the parties in respect of which the alleged assumption could form the conventional basis. And Mr. Tinkler raises this point for the first time in this court. It formed no part of his case at any stage below, and it derives from what was the fourth ingredient in the Blindley-Heath formulation of conventional estoppel as taken from Bench Holiday, which described it, or put it in these terms, that reliance must have occurred in connection with some subsequent mutual dealing between the parties. Here, however, it's elevated into a gateway condition that there must be a transactional course of dealing, and that there was none in this particular case. We certainly agree by reference to the authorities, in particular the Grunt case, the Australian case, which is in the authorities at tab 25, that the convention must relate to contractual or other mutual relations, as it was put in that case. In other words, convention estoppel applies where a common assumption has resulted in a convention which operates in respect of contractual or other mutual dealings between the parties concerned. Here we have mutual dealings. We have dealings between Mr. Tinkler and the revenue in respect of Mr. Tinkler's tax return for 2003-2004, which dealings were carried on for about a decade. The convention which operated in respect of those dealings was that the revenues inquiry had been validly opened. That is all that is required. Insofar as Mr. Tinkler's position is that the mutual dealings must amount to a transaction, which appears to be suggested subsequently at paragraphs 73 and 74 of his written case, I say that submission is wrong. A submission that a transaction is required to be made was put and rejected by the Court of Appeal in the case of the Vistaford. That is at Authorities, tab 16, on page 1102 of the bundle.
Mr. Gammy, you don't need to tell us the tab number because none of us have the authorities in paper form. It's quite sufficient that you give us the electronic page. Thank you.
Thank you, my lord. I'm grateful to you for that. So on page 1102, you can see the Court of Appeal case, the Norwegian American Cruises versus Paul Mundy Limited, the Vistaford. And if you go to page 1109, you can see in the second column the second paragraph down, the plaintiffs challenged this approach. They submitted first there was no conduct crossing the line between the plaintiffs and the defendants, as was necessary to give rise to an estoppel by convention or any other type of estoppel. Secondly, they submitted that it was not shown, as was necessary, that both parties had entered into a transaction between themselves on the basis of this agreed assumption. And Lord Justice Bingham addresses that submission on page 1110 of the report. It's in the penultimate paragraph beginning the second submission, in the first column, the second submission, and he quotes from a decision of Mr. Justice Peter Gibson, as he then was, in a case called Hamill-Smith, where Mr. Justice Peter Gibson had said, among other things, I do not see why the parties need to be about to enter a transaction when they make the common assumption. As he also said, estoppel by convention is not dependent on a contract, but on a common assumption. And also he said, what is important for an estoppel by convention is that there should have been a common assumption which has been acted upon. So that's relying on Justice Peter Gibson and the quotations that he makes in the second column on that page. And then on page 1111, we see that Lord Justice Bingham says, I respectfully agree entirely with and endorse the learned judge's analysis in that passage. And we submit that that is entirely correct, and that there is no principled basis to limit estoppel by convention to cases involving a transaction, however one might interpret the word transaction. We say it's evident from cases such as bench dollar, which concerned estoppel by convention in the context of arrangements intended to postpone a limitation period, that I'll take you to shortly, that a transaction is not a necessary requirement. So I say that deals with Mr. Tinkler's first gateway point. His second gateway point is based on Lord Justice Oliver's judgment in Keane and Holland. And again, the argument is set out in paragraph 66 of his written case at page 121 of the bundle, where we see in the second part, he says, secondly, estoppel cannot override a statutory provision where one, the parties are unable to vary or displace that provision by agreement, or two, it would be contrary to public policy or the statutory purpose for estoppel to be allowed to override the relevant provision. This point, based on Keane and Holland, was first introduced by the upper tribunal of its own initiative. At that stage, Mr. Tinkler rejected the argument offered by the upper tribunal because he considered it to be without merit. He now relies on that argument as a key point of his case before this court. And as we can see from paragraph 66, there are two limbs to this argument, both derived from Keane and Holland. The first limb is that estoppel cannot override a statutory provision where the parties are unable to vary or displace that provision by agreement. And the second limb is that estoppel cannot override a statutory provision where it would be contrary to public policy or the statutory purpose. Before addressing each limb in turn, it's helpful to put the arguments in their proper context. And to do that, I'll show you what was said in Keane and Holland. Now that is in the bundle at page 1046. And as you can see, and as you may be familiar, the case concerned the Agricultural Holdings Act 1948, which of course gave security of tenure to agricultural tenants. But the circumstances that had arisen in Keane and Holland was that the landlord was not prepared to grant a tenancy that would attract security of tenure under the Act, and had sought to grant a tenancy which did not attract security of tenure. And the case raised two issues. First, whether the tenancy agreement had successfully achieved the landlord's objective of avoiding the security of tenure provisions of the Act. And secondly, whether the tenant was stopped by convention from relying on the provisions of the Act. The landlord lost on both issues at first instance and on appeal. And the judgment of the Court of Appeal was given by Lord Justice Oliver, as he then was. And the loophole that the landlord was seeking to exploit or take advantage of, but which he failed to do so, can be seen on pages 257 and 58 of the report, which are on page 1052 of the electronic bundle. And you can see in particular the paragraph at the bottom of page 257, just below G, where it talks about what the legislature had provided security of tenure for, and where it had overlooked, you can see this just below H, the case of a tenancy for a fixed term of more than 1 but less than 2 years, and that such a term was held in Gladstone and Bower not to be a protected tenancy. So that was the type of tenancy that the landlord in this case was trying to set up, but which the court concluded he had failed to do. And then, having concluded that it failed to set up the correct form of tenancy to escape the Act, the court turned, or Justice Oliver turned, to consider the estoppel argument, which begins at the final sentence of the report on page 259 of page 1054 of the bundle. And the primary basis for rejecting the argument, the estoppel argument, appears in the report at page 261, which is page 1056 of the bundle. And perhaps I could just invite you, my lords, my ladies, to read the paragraph starting just below C, where it's attractively, as this argument was put, through to the bottom of that paragraph at F. So, just by way of explanation, Johnson and Morton, or Moreton if it is, referred to there, was a decision of the House of Lords in which it was held that a covenant in a lease of an agricultural holding, which purported to prevent a tenant from serving a counter notice to a notice to terminate under the 1948 Act, was invalid as being contrary to public policy. So there was a previous authority that trying to step outside the Act in that way was contrary to public policy. And I say what Lord Justice Oliver is saying here is that Parliament has provided that the security of tenure provisions will apply to agricultural holdings no matter what. It's not possible for the parties to oust those provisions by agreement, and attempts to do so would be ineffective. And if the parties could not achieve that effect by contract, then they could not achieve it by means of convention estoppel. That is what my Lord Briggs in bench dollar subsequently identified as the primary basis of the decision in Keane and Holland. For your note, that is the report of bench dollar, which is a page at paragraph 46, which is on 1241 of the bundle. Yeah, looking still at Keane and Holland, though, if we go on to page 261 of the report, which that's 10/56 of the bundle, at F on that page, through to C on the next page, Lord Justice Oliver also set out further reasons why the estoppel argument would not work in that case. And perhaps I could invite you to read from the paragraph beginning, "That is sufficient to dispose of the argument," through to the end of his judgment. As my Lord Briggs explained in Bench Dollar at paragraph 48 of his decision, the precise meaning of these passages has been the subject of some debate. So I think we need just to look at Bench Dollar here, which is at page 1242 to 1242 of the bundle. We're looking at paragraph 48 at the bottom, towards the bottom of the page. And as my Lord Briggs noted in paragraphs 49 to 50, these passages of Lord Justice Oliver's judgment in Keane and Holland have been relied upon for the following propositions. First, that a shared incorrect assumption as to the true construction of an agreement is not by itself sufficient to found an estoppel by convention. Secondly, that a common assumption as to the meaning of an agreement reached individually rather than mutually expressed to each other cannot give rise to an estoppel. And thirdly, that some course of dealing after the contract in question has been entered into is necessary. And finally, as my Lord noted at paragraph 48, strictly speaking, Keane and Holland dictum was not strictly applicable in Bench Dollar because it is concerned with an estoppel alleged to have been created within a contract. For the same reason, it's not strictly applicable in the present case. Nevertheless, having put Keane and Holland and Lord Justice Oliver's decision in context, let's turn to Mr. Tinkler's argument in the present case. As regards the first limb of the argument, that estoppel cannot override a statutory provision where the parties are unable to do so by agreement, the Revenue's position is straightforward. The Revenue are not seeking to override a statutory provision, nor are the Revenue seeking to achieve by estoppel something which could not be achieved by agreement. It is entirely possible for the Revenue and a taxpayer to agree as to how the requirements of section 9A as to the notification will be met. Indeed, it has always been accepted by Mr. Tinkler that it would have been possible for him to agree with the Revenue that notice could be validly be given to his nominated agent, for example, BDO. And that proposition has already been established in a materially similar context in a case called Spring Salmon. That case is in the bundle at page 1251. And this was a Scottish case that will be familiar to my Lord Hodge. And it concerned a notice of inquiry in respect of a taxpayer company which had been given to the company's agents rather than being served at its registered office. The notice of inquiry in Spring Salmon had to be given pursuant to paragraph 24 of Schedule 18 to the Finance Act 1998, which relates to corporation tax. But the relevant terms of that provision, paragraph 24, are materially identical to those of Section 9A of the Management Act. It was held that because the company had agreed to the notice being sent to its agents, the notice had been validly given. You can see that at page 1261 of the bundle, and in particular paragraphs 37 to 38. 38 is at the top of 37 is on the previous page, discussion 1260, but then 38 contains the substance of the conclusion by Lady Smith in that case. And this was also a case, as you can see from the going on under the heading personal bar, in which the court held obiter that the taxpayer was personally barred from challenging the notice of inquiry for the reasons given in paragraph 39, which is at the bottom of page 1261. Now, returning to the present case, it's common ground that a valid notice of inquiry could have been given to Mr. Tinkler by sending the inquiry letter to BDO with his agreement. So this is not a case where the revenue are seeking to achieve something by estoppel that could not have been achieved through agreement. And it's instructive to look at how the upper tribunal and the Court of Appeal dealt with this particular point. In the upper tribunal, neither party supported an analysis that estoppel by convention was effectively precluded as a matter of law by virtue of Section 9A of the Management Act. I'll take you to the relevant passages because they're only quoted in part in Mr. Tinkler's written case at paragraph 79. The relevant passages are paragraphs 56 and 57, which are at page 176 of the electronic bundle. And looking at paragraph 56, we can see at the beginning the origins of this particular point. So during the hearing, we put it to the parties that the ratio of Keene v. Holland appeared to be that estoppel by conversion cannot override the specific protection afforded by an Act of Parliament. We raised the question whether Section 9A of the Management Act might provide such protection. After considering the question, Mr. Thomas indicated and subsequently confirmed in writing that his view was that the principle in Keene and Holland is not of material assistance in resolving this case. And then we can see, if you care to read on in paragraph 56 and 57, you can see what the upper tribunal went on to say on this particular point and the conclusion they reached in paragraph 58. What the Court of Appeal had to say about this is at paragraph 73 of the Court of Appeal's decision, which is at page 161 of the bundle. where they just say in these circumstances it's not necessary to address the legal issue of whether or not it's possible to contract out of the statutory protections conferred by Section 9A, I would have observed that I would take some persuading that Keane and Holland is analogous, and that Mr. Thomas's QC's argument on issue 1 acknowledges that the requirements of Section 9A may be varied by agreement. So the Court of Appeal observes correctly in our submission that the revenue are not seeking to achieve by estoppel, which could not be achieved by agreement. As regards the second limb of Mr. Tinkler's Keane and Holland point, which is that estoppel cannot override a statutory provision where it would be contrary to public policy or the statutory purpose, we say this. First, this argument is essentially part and parcel of the unconscionability issue, which I'll come to. It is essential to establish an estoppel by convention that it would be unconscionable for a party to resile from a common assumption, and an assessment of unconscionability depends on all the circumstances, including the context in which the common assumption has been generated. Here, that context includes the requirements of Section 9A. Secondly, it's not contrary either to public policy or to the statutory purpose to hold Mr. Tinkler to the common assumption that a valid inquiry into his 2003-2004 tax return had been opened. The parties could have expressly agreed that valid notice of the inquiry could have been given to Mr. Tinkler by sending the inquiry letter to BDO. And if that is not contrary to public policy or the statutory purpose, on what basis is it contrary to policy or the statutory purpose to hold Mr. Tinkler to a common assumption to essentially the same effect? Mr. Tinkler's argument at paragraph 83 of his written case, if we go to that, it's at page 127 of the bundle, where he says, in deciding whether the statutory provision should be seen as capable of being excluded on the grounds of estoppel, it's to be appreciated that, were the situation reversed, a taxpayer could not plead estoppel against the commissioners. Thus, if, for example, a taxpayer thought that he had been permitted by the revenue to amend his self-assessment return after the statutory period had expired, he would be met by the argument that the revenue could not be stopped from carrying out their statutory duty. It's inconceivable that an estoppel allegedly arising out of mutual dealings could only operate in one direction. I say that suffers from two particular defects. First, it overlooks the fact that public authorities are subject to public law and to public law remedies, including the doctrine of legitimate expectation, as indeed Lord Hoffman explains in the Reprotect case that my learned friend refers to. Secondly, the example on which reliance is placed by Mr. Tinkler is of no assistance because it's not comparable with the present case. He posits the scenario of a taxpayer not being permitted to amend his or her self-assessment return after the statutory deadline. But that is not a helpful example because that deadline is an incontrovertible feature of the statute. But we're dealing with a case in which the common assumption arose and was pursued before any time limit had expired. And thirdly, it cannot be the case that estoppel by convention is necessarily precluded as a matter of law from operating in circumstances involving a statutory provision which imposes a procedural requirement which might be characterized as providing protection to someone. It was no bar to the operation of estoppel by convention in bench dollar that the revenue was seeking to stop the taxpayers from relying on the protections of the Limitation Act 1980. That was because it accepted that parties are free, in effect, to contract out of the Limitation Act by effectively substituting a longer limitation period for that provided by the statute. Likewise, it's accepted that the revenue and a taxpayer can agree to give how notice under Section 9A might validly be given. In short, I say the ratio in Keene and Holland has no application in this case, as the Court of Appeal, and indeed Mr. Tinkler himself, recognised at earlier stages of this litigation. So I say that is my response to my learned friend's gateway conditions, as he puts them in Mr. Tinkler's written case. And I will now turn to address what in our submission are the two key issues. The first being whether Mr. Tinkler, acting by his agents, BDO, assumed the requisite element of responsibility for the common assumption between the parties that an inquiry had validly been opened. And secondly, is it unconscionable in the circumstances for him to resile from that common assumption? The two are closely related and reflect that the objective is to identify the circumstances in which it would be unjust for a person to be permitted to resile from a common assumption that has formed the conventional basis of their mutual dealings with another party. Thus, estoppel by convention operates where the common assumption has been communicated between the parties and the estopped party has played his or her part in the adoption of that assumption, such that it would be unconscionable for him or her to resile from it. It is the concept of injustice or unconscionability that lies at the heart of the ingredients for conventional estoppel, as identified in Bench-Dollar and Blindley-Heath. Now, in what follows, in my following submissions, I'm going to devote the majority of my time looking at the issue of the assumption of responsibility. And in the light of what I've shown you on that, I shall be able to deal relatively briefly with the issue of unconscionability. So the first stage in this analysis is to ask what assumption of responsibility requires for the purposes of this estoppel. And the appropriate starting point is to look at the summary of the ingredient given by my Lord Briggs in Bench-Dollar at page 1243 of the bundle, where he summarizes at the bottom of the page, starting in paragraph 52, the principles applicable to the assertion of an estoppel by convention arising out of non-contractual dealings. And at over the page, 1244, we see at 2, he says, the expression of the common assumption by the party alleged to be estopped must be such that he may properly be said to have assumed some element of responsibility for it, in the sense of conveying to the other party an understanding that he expected the other party to rely upon it. In our submission, the requirement that the party sought to be estopped should have assumed some responsibility for the common assumption is designed to exclude from the scope of the doctrine cases where, exclude from the scope of the doctrine cases where each party has acted on the basis of the same incorrect assumption, but that assumption has been reached independently by each party, or in other words, each party has kept his or her own counsel. One can see that from the following. First, the passages cited from Spencer Bauer in the immediately preceding paragraph 51 in Bench-Dollar, where if one looks at paragraph 51, one sees, particularly in the second citation from Spencer Bauer, just below H, it says, in the context of estoppel by convention, the question here is whether the party estopped actually, or as reasonably understood by the estoppel raiser, intended the estoppel raiser to rely on the subscription of the party estopped to their common view, as opposed to each keeping his own counsel, being responsible for his own view. And an example of that can be seen in the case of Wilson and Truelove, which is referred to by Lord Briggs in paragraph 51 of Bench Dollar, where estoppel by convention could not arise because, among other reasons, the parties had independently reached the same erroneous view of the legal effect of one of the terms of their contract. For your note, that is the case Wilson and Truelove is at page 1315 of the bundle. I don't think we need go to it specifically just to see that point. But one sees the principle also reflected in the early authorities. So again, and we cite this in our written case from Grunt, where it said that the party to be estopped must have played such a part in the adoption of the assumption that it would be unfair or unjust if he were left free to ignore it. And again, in a case called the August Leonhardt, where it said that the basis of the estoppel is the participation by the party to be estopped in some, as it was put in that case, mutually manifest conduct. Again, cited in our written case at paragraph 42, and it is at page 1044 of the bundle that comes from. So
Mr. Galley, can I just ask you something? Look at proposition 2 at the top of page 1244, the one you're dealing with in Bench Dollar. I finished by saying, an understanding that he expected the other party to rely on it. As a matter of pure language, that might appear to mean just the common assumption. But if you go back to the citation from Spencer Bauer on the previous page, it appears not to be on the common assumption, but upon the party to be estopped subscription to it. Is that a fair gloss on proposition 2? On the subscription of the party estopped to their common view.
Indeed. So, in other words, some reliance by the person who's seeking to set up the estoppel on the other party's subscription to the common view.
In other words, not on the assumption itself, but on the very fact that the assumption is shared by the other party.
Indeed, my lord, I think that is. So if, for example, it could be demonstrated that nobody had ever relied upon something, even though it was their common assumption, but it had never been relied upon, then, I mean, that would also tie in with the question as whether or not it was unconscionable of the party who was resisting the estoppel to resolve from it, because he would say, well, you never actually, I know I subscribed to this, but you never actually relied upon it. I think that, my lord, is the sense in which you're describing it, both in Spencer Bauer and in what you summarised at paragraph 52. Does that deal adequately? Yes, thank you, Lord. So, as I say, in our submission, the key mischief that the assumption of responsibility ingredient seeks to address is to draw a distinction between two types of case. The first type of case concerns a situation where the party said to be estopped has participated in such mutually manifest conduct which might involve, for example, endorsement of, reinforcement of, or agreement with a given assumption. And in that scenario, estoppel by convention can apply. So we'll come to what Lord Denning said in amalgamated property in due course. But the second type of case would concern a situation in which the position taken by each party has been arrived at independently, or situations in which each party keeps its own counsel. In that situation, estoppel by convention cannot apply because there's been no communication by the party to be estopped to the estoppel raiser that he shares the relevant views, such as to render him accountable to the estoppel raiser for its correctness. And we say that ingredient, properly understood, explains why estoppel by convention could not apply in the August Leonhardt. And here, if we go to page 1044 of the bundle, and in the second column, we can see that it said, although there was, I'm just trying to, yes, it's the paragraph beginning the word inaction is the paragraph you're looking at, and then if you go down about 12 lines or so, you have a sentence which begins, although there was a misunderstanding which put them at cross purposes, we also agree that one can go a stage further by saying that thereafter they both assumed, albeit for different and mistaken reasons, that the Charterers' agreement had in fact been obtained, and that an extension of time to April the 26th, 1982 was therefore in force between the ship owners and the cargo owners. But this is where the matter stopped, in the sense that nothing thereafter crossed the line between them. Mr. Short understandably relied on his assumption by not issuing a writ, but he did not do so in reliance on anything said or done by Mr. O'Donovan, which might have been capable of giving rise to an estoppel. All estoppels must involve some statement or conduct by the party alleged to be estopped, on which the alleged representee was entitled to rely and did rely. I think that's, my Lord Bruce, that I think is the point you've just raised. As he goes on, in this sense, all estoppels may be regarded as requiring some manifest representation which crosses the line between the representor and representee, either by statement or conduct. It may be an express statement, or it may be implied from conduct. For example, a failure by the alleged representor to react to something said or done by the alleged representee so as to imply manifestation of assent, which leads to an estoppel by silence or acquiescence. Similarly, in cases of so-called estoppels by convention, there must be some mutually manifest conduct by the parties, which is based on a common but mistaken assumption. The alleged representor's participation in this conduct can then be relied upon by the representee as a basis for this form of estoppel. So I say that that is what the assumption of responsibility ingredient is getting at. So against that background as to what this particular ingredient of the estoppel is aiming at, why on the facts is the assumption of responsibility ingredient present in the present case? So first, I think one needs to turn to the Revenue's letter to BDO, which is at page 254 of the bundle. And here we can see it's dated 1st of July 2005, so the same date that was the inquiry letter was sent to Mr. Tinkler himself. And as it says, I enclose for your information a copy of the Section 9A Taxes Management Act 1970 notice, which has today been issued to your client in respect of his return of income for the year ended 5th April 2004. And then various questions are asked, and the enclosure is at page 256 of the electronic bundle, and you'll see that this is the letter that Mr. Mackay sent to Mr. Tinkler at his Haybridge Lane address. So BDO have been provided with a copy of the inquiry letter sent to the wrong address. So when Mr. Tinkler says at paragraph 6 of his written case that the parties are agreed that no notice of inquiry was ever served on BDO, that is not correct, in the sense that the BDO were sent a copy of the notice of inquiry. Of course, the Court of Appeal concluded that they were not Mr. Tinkler's agents for the purpose of receiving that statutory notice, but they were certainly sent a copy of it. Now, if we return to page 254 and the Revenue's letter to BDO, the Court of Appeal said that the Revenue made a misrepresentation in their letter to BDO, and that the Revenue were at fault for what happened. In our respectful submission, that characterization of the relevant events is not correct. It's unclear what misrepresentation the Court of Appeal had in mind. It didn't spell it out, and one would think that it could only be that the Revenue's letter contained an implied representation that the copy letter had been sent to Mr. Tinkler's correct address. But BDO could see where the letter to Mr. Tinkler had been sent. They were provided with a copy of the inquiry letter, including the address, and BDO had at least the same amount of information about Mr. Tinkler's correct address as the Revenue had. In his written case, at paragraphs 14 to 17, Mr. Tinkler asserts without evidence that this is not correct and that BDO did not know Mr. Tinkler's residential address in July 2005. But even if that assertion is correct, BDO had access to Mr. Tinkler as their client to check with him whether he had received the letter before they started responding to the Revenue's inquiries. Mr. Tinkler accepts in his written case, at paragraph 18, that BDO were told that the Haybridge Lane address was incorrect in October 2005, and said nothing about this to the Revenue in connection with the inquiry notice. So even if the Revenue had made an implied misrepresentation that the letter had been sent to the correct address, which the Revenue does not accept, certainly doesn't accept it as a misrepresentation, the BDO at the very least had the means of knowing that a mistake had been made.
Sorry, where do we, Mr. Gammy, where do we find that fact that BDO were told that the Haybridge Lane address was wrong in 2008 and did nothing to correct it? Where did we get that from?
My lady, it's in the notes. There were notes of telephone conversations, I think, between BDO and the Revenue at the end of October. I'll see if I can find which precise document it is, but it was at that point in time, at the end of October, when BDO, having said that they would respond to the inquiries that were raised or the questions that were asked in the Revenue's letter of the 1st of July 2005, and they said they would respond by the 22nd of August, which they failed to do. The Revenue then followed up with successive letters to BDO and eventually an information notice to Mr. Tinkler, copied to BDO, seeking answers to the questions that they raised. That then led to a series of telephone conversations between BDO and the Revenue, in which it emerged that, or it became clear around that time, that Haybridge Lane was not was no longer his residential address. I think it's actually in Mr. Tinkler's written case, paragraph 18 at page 104.
Mr.
So,
Cameron,
yes, my lord.
it is not the representation that the inquiry had been validly opened by they call it issue, by the delivery in one way or another of the letter of which they sent a copy. I say that because the questions in paragraph 2 about capital gains appear to be about the tax year in relation to which the inquiry notice had been given. So that the Revenue appeared to be saying, well, we've issued this inquiry, so we would like you to help us with the following matters.
Indeed, my lord, I think if I understood you correctly, I think I agree with that. I mean, from the Revenue's perspective, the officer takes a decision that he wants to inquire into a tax return. He writes a letter saying, I'm opening an inquiry, and he posts it, as indeed the first tier tribunal concluded that that had happened. And he, at the same time, he sends it to the known agent, BDO. At that point, of course, he's no idea on the 1st of July whether or not the letter has been, well, it will not have been delivered to the taxpayer or received by the taxpayer on the 1st of July, unless he happens to sit in the same room as the taxpayer and hand over the letter to the taxpayer. But as far as the officer is concerned, he has taken the steps necessary to open an inquiry by writing the letter and posting it. The defect or deficiency, if you like, in this case, is that, as the first tier tribunal found, that letter was not actually received by Mr. Tinkler because Mr. Tinkler was no longer resident at that address, and the arrangements he'd previously made for mail to be forwarded to him had obviously fallen into abeyance. The inquiry for the previous tax year had been sent to that address, again at a time when Mr. Tinkler was no longer resident there, but evidently had been passed on to him so that he did receive it. So, as I say, Mr. Tinkler accepts that by October at least, BDO knew that Haybridge Lane was not was no longer his residential address and hadn't been at the time. So even if the Revenue had made an implied misrepresentation that it had been sent to the correct address, as I say, which we don't accept, that was misrepresentation, the BDO had the means of knowing that a mistake had been made. And if, as the Court of Appeal held, BDO had not been appointed as Mr. Tinkler's agent to receive the notice of inquiry on his behalf, it's difficult to understand why they would not have checked with Mr. Tinkler that he had indeed received the notice of inquiry before responding to the Revenue's inquiries in their letter of the 1st of July. In any event, it's clear that at this stage, on the 1st of July 2005, the Revenue considered that an inquiry had been opened, and that's the assumption that the Revenue have made. So now we need to look at BDO's response to the Revenue.
By October 2008, was it already too late for them to reopen the inquiry, or was the time limit still running?
My lady, the subsequent, so the return had been filed on the correct date, 31st of January. The revenue had 12 months in which to open an inquiry. So all of this took place within the 12-month period. In fact, as we see from from BDO's letter of reply, we'll see that they purported to amend his return, which would have extended the period in which the revenue could have opened an inquiry beyond the normal 12-month period. But in fact, all of the actions that we're going to look at were within that 12-month period. So I was going to go on, my lord, to sorry, I was going to go on, my lord, to look at the to BDO's reply, but that may be an appropriate point to take a 5-minute break.
Just before we take that break, you referred us to paragraph 18 in Mr. Tinkler's case, which vouches the fact that BDO were informed that Mr. Tinkler no longer rented Haybridge Lane. I think you mentioned that there was a telephone conversation between BDO and the revenue, where that was communicated to the revenue. Have I misunderstood you in that regard?
No, my lord, that is also correct, because on the 1st of November, the revenue amended their records to change the Haybridge Lane address to the Station Road address.
Yes. Well, if we have before us the relevant note of the telephone call, I'd be keen to see it. But we can deal with that after the adjournment. The court will now adjourn for 5 minutes. Thank you. All you have to do, Mr. Gami, is stop your video and mute your microphone. Mr. Gami, I think we're ready to resume. Thank you.
Thank you, my lord. My lord, you were asking before that short break about the telephone conversations that had occurred between the revenue and BDO. They're recorded in the agreed statement of facts at paragraph 21, which is on page 53 of the bundle. The original source material, the notes of those conversations, start at page 266 in the bundle. One of the particular aspects of this was that the revenue had issued a repayment to Mr. Tinkler in August. They'd sent him a check, and they'd sent it again to the Haybridge Lane address, and it had not been received. And that was one of the issues that was raised in the conversations, which are recorded in the notes. The material runs from page 266 of the bundle through to page 270, and there's a letter at page 271 from Mr. Tinkler confirming his bank details. The check was cancelled and the money was paid by BACS transfer. But it's in the context of those notes that it's said about Haybridge Lane no longer being his address. And as I said, on the 1st of November 2005, the revenue changed their records to record the care of address at his employer, Station Road, as the address to which correspondence should go. So that's the material, and what I was about to take you to was the BDO's response to the Revenue's letter of the 1st of July, which is at page 258 in the bundle. So it's a letter of the 6th of July. You see that the subject line says 2004 self-assessment tax return - section 9A TMA 1917 notice. And we acknowledge receipt of your letter advising us as to your intention to inquire into the above tax return. So they acknowledged receipt of the inquiry letter, and they then address certain of the questions or issues that have been raised in the letter to BDO. And then in the penultimate paragraph on the same page, they explain that an issue has arisen in relation to the 2004 tax return. And in the final paragraph of that page, they explain that their view is that Mr. Tinkler has suffered an income tax loss of around £2.5 million, arising out of what the Revenue considers to be a tax avoidance scheme, which is already being investigated or inquired into through the promoters of that scheme. You see that over the next page, page 259, the first paragraph. We would ask you to note that this particular transaction is also the subject of a central inquiry between the Revenue and Grant Thornton LLP, promoters of the scheme. And then in relation to the effect of that scheme, the £2.5 million loss that is said to arise from that scheme, they say this transaction should, of course, have been included on the 2004 tax return, and in normal circumstances, we would amend the return to incorporate it. We are, of course, precluded from doing this, as the return is now subject of a Section 9A TMA 1970 inquiry. So pausing there, of course, if there was no valid inquiry, the amendment to Mr. Tinkler's tax return that BDO are notifying on his behalf could take effect and would then require the Revenue to give an inquiry notice within an extended time window. But as I noted before the short break, all of this material is still within the original 12 months allowed for opening an inquiry, even allowing for its subsequent amendment. But instead, of course, BDO in their letter state expressly to the Revenue that their view, their understanding and their assumption is that the return is now the subject of a Section 9A inquiry, so that that is not required. And of course, they say that in terms. Pausing here, Mr. Tinkler says in his written case, at paragraph 101, which is at page 133 of the bundle, that BDO were hardly in a position to indicate or otherwise make representations to the Revenue as to whether or not the inquiry notice had been received. And I say that is not strictly correct. The Court of Appeal held that BDO did not have authority to receive the notice on Mr. Tinkler's behalf. But it does not follow that BDO were not in a position to make representations to the Revenue as their client's agent as to whether their client had received the inquiry notice. So turning back then to page 258.
Mr. Gammy, can you
Yes.
just can you
Yes.
explain why you say that doesn't follow? Why, if they've been held not to have apparent authority, actual or apparent authority, actually to receive the notice on his behalf, how can they have authority or actual apparent authority to make representations or communications which achieve broadly the same result? What authority do they have to do that on behalf of Mr. Tinkler?
Well, my lady, they are his appointed agent for dealing with correspondence and inquiries from the Revenue. So the Court of Appeal certainly concludes that they did not, that the authority that they held to deal with his tax affairs and to deal with Revenue's inquiries did not extend to an authority to receive a statutory notice on his behalf. because the terms of the Act and what had been agreed between the revenue and the professional bodies was that inquiry notices should go to the taxpayer. Now that the revenue and the taxpayer could agree something different, but they hadn't in this case. So that was not within the scope of BDO's actual or apparent authority, but BDO had been appointed to deal with correspondence, and the revenue material, the material for inquiries, says quite clearly that the revenue will correspond with your agent in relation to inquiries that the revenue raise about the tax return. So BDO was still his agent. They were not his agent to receive the statutory notice, but they were certainly his agent who would deal with inquiries that were raised by the revenue and that would correspond with the revenue. So
Yeah,
I
so
think
I'm not that much is clear, but you're not just relying on their correspondence. You're saying that things from BDO which cross the line from BDO to the revenue are crossing the line from Mr. Tinkler to the revenue, because he is the one who's stopped, not BDO. So how can they be crossing the line from Mr. Tinkler to the revenue if they don't have authority to receive a notice on his behalf? Isn't that something slightly more than just dealing with correspondence from the revenue?
well, my lady, so the revenue open an inquiry by issuing a letter to the taxpayer, but the taxpayer has authorised his agent, in this case BDO, to deal with the inquiries that the revenue raise pursuant to their having opened the inquiry. So I have to say, I don't see on what basis, if there is a common assumption that there is an inquiry open and that those inquiries have to be dealt with and answered, and BDO are his agent for doing so, then I would have submitted that BDO, in dealing with those inquiries, is joining with the revenue in the assumption, or certainly is joining Mr. Tinkler to the revenue's assumption that an inquiry has actually been opened through the service of a notice, even though, as I say, in this case, it's shown that the notice was never actually received. So BDO were his agent for this purpose, and that was what the first tier tribunal found at paragraphs 144 and 145 of its decision.
Mr. Cammy, can I just clarify my understanding as to what you've just said? It's no part of your submissions that the Court of Appeal made an error in relation to its approach to the law of agency in this particular case, is perhaps the way I'd put it.
Certainly not in relation to what they found about the service of the statutory notice. I mean, the revenue's appeal, the revenue has not did not seek permission to appeal that part of the Court of Appeal's decision, but that doesn't strip BDO of any authority to act as Mr. Tinkler's agent in dealing with inquiries. So, as I say, if we turn back to BDO's letter of the 6th of July, which is at page 258 in the bundle, we can see that they ask in the third sentence of the first paragraph. I'm just trying to see where it. Yes, it's so on the second page of the letter, for example, in relation to section to the years 2003, 4 and 2004, 5, they having asked that the transaction of the giving rise to the loss should be dealt with. In relation to 2003-4, they say, we appreciate that you're unable to amend the 2003-4 return tax liability as it's due to an open inquiry. Then they ask that the revenue nevertheless repay 605,000 tax overpaid for the year. But that was not in fact repaid because the revenue did not give effect to the amendment, because they regarded the return as under inquiry, and therefore effect could not be given to the loss because even though the return was amended, there was an open inquiry. That's the first point. And then they go on to say in the second paragraph under 2003-4, additionally, as the 2003-4 tax liability based on the original tax return was paid late, Ms. Tinkler charged a surcharge. They ask that that's reduced. And they also ask in relation to 2004-5 that tax payments on account should be reduced. And that was in fact done. So I say in relation to the BDO response overall, we say what BDO has done is in fact two things. First, they've expressed to the revenue that they understand that an inquiry has been validly opened. That's not a view they reach and then keep to themselves. They state that understanding in terms to the revenue. And secondly, the expression of that assumption conveyed to the revenue an understanding that the revenue could rely upon it. In other words, the revenue need take no further steps to open an inquiry into Mr. Tinkler's return, because that inquiry was on foot. Rather, the revenue should take various steps to repay tax pending resolution of the inquiry into the return. And as I say, in accordance with BDO's request, the payments on account for 2004-5 were reduced, and a refund of some £42,000 was subsequently issued on the 30th of July, that being the payment that then the cheque was not received and had to be dealt with by the BACS transfer in October, November. So we say that in this respect, the parts of the Court of Appeal's reasoning in its judgment are unsustainable. If we go to what the Court of Appeal said at page 160 of the bundle, and we look at what the court said at paragraphs 65 through to 69, in particular, the Court of Appeal said that BDO at no stage endorsed, affirmed, or addressed the truth or accuracy of the statement made to them. The validity of the inquiry was not a matter that was ever referred to or considered in communications between the parties. I say that the BDO letter we've looked at does precisely that. And similarly, in paragraph 66, where the court says BDO played no part in the adoption of the assumption, again, I say that is not supported by what BDO wrote to the revenue on the 6th of July. Similarly, in paragraph 66, where the court says the revenue did not need or seek assurance from BDO that their assumption was correct, nor was any such assurance given, BDO neither said nor did anything to show that the assumption reflected its own understanding, rather than simply what it had been told by the revenue. But I say what BDO did goes beyond that. And similarly, at 69, where the court says that BDO did nothing to cause the adoption of the mistaken assumption, I say that that is not correct, given the correspondence, even the correspondence on 6th of July, let alone anything that subsequently occurred. And indeed, as I say, as the court will have seen from the bundle, and as we've alluded to in relation to events at the end of November, end of October and into November, BDO's letter of the 6th of July was not the end of the matter. The parties continued operating on the basis of their common assumption that the return was under inquiry for almost a decade, of course, before Mr. Tinkler decided to resolve from it. And prior to that, BDO, acting on his behalf, had actively engaged with the inquiry, including most relevantly during the time window within which the revenue could have opened an inquiry or could have corrected the error, or at least sent the letter again to Mr. Tinkler to a different address, to a new address. And Mr. Tinkler, of course, appealed the closure notice issued in respect of that inquiry. And that closure notice had, as BDO. Yes, my lady.
Sorry, can I just get clear in my own mind facts of this 28th of October exchange about the cheque not arriving? What you're saying is that in that exchange, according to those notes, BDO told HMRC that the Haybridge Lane address was not a valid address and the cheque had not been received and had to be cancelled. And that was within the 12 months from during which HMRC could open an inquiry. So that within that 12 months period, HMRC did know that the Haybridge Lane address to which they'd sent the Section 9A notice was not sent to the correct address.
Well, my lady, when you say the correct address, as I said right in opening, the Act does not specify the address. In other words, it's not a statutory notice that, for example, as in the case of a company, for example, it's specified that this has to be served at the company's registered office.
No, but it's an address. All right, let me put it slightly differently, that it had been sent to an address which HMRC now know was not an address at which Mr. Tinkler received correspondence, to the extent that a cheque sent there was regarded as having gone astray and had to be cancelled and resent. Now, if that's the factual position, and then HMRC did not then act upon that by thinking, well, if that cheque has not arrived, maybe the Section 9A notice didn't arrive either, but they didn't then ask the question or resend the Section 9A notice. Is that a fair summary of the facts?
Well, by that stage, BDO had already engaged with them in relation to the inquiry. So they had, and indeed, the letter for the previous year had been sent to Haybridge Lane at a time when Mr. Tinkler was not resident there, but had nevertheless been received by him. So there was no issue about the previous year's inquiry notice, which had gone to Haybridge Lane. So from the revenue's perspective, Mr. Tinkler's agent was already engaging with them in relation to the inquiry and continued to engage with them in relation to the inquiry, both before and after they became aware that the address, the Station Road address, was the address that he wanted registered, they would not have known unless they were told by BDO that the inquiry letter had not been received by Mr. Tinkler. They had no means of knowing that. All they knew was that BDO was engaging with them both before and after knowledge of Haybridge Lane in the inquiry that they'd opened on the 1st of July. Well, as far as the revenue knew, and their assumption was that it was an open inquiry.
Isn't there also, in this type of situation where you're complaining about a formality in a notice which would render it invalid, that you take the point immediately? Because there's no point going on with the discussion about the inquiry if you know there is this point and don't take it. Isn't it a sort of matter of commercial life that you take this sort of point pretty soon?
Well, my lady, I think I would agree with that. I mean, I think all I would say is what I said to my lady Rose, that as far as from the revenues perspective, both before and after this knowledge came their way that Haybridge Lane was no longer his address, there was Mr. Tinkler's agent was engaging with them on an inquiry. Now, I mean, as we'll see in Lord Dennings, who draws in a case we'll come to, draws the sort of situation between somebody who acts sort of deceitfully in the sense that they know that the other party has made a mistake and doesn't say anything about it when they should. I mean, in this particular case, I mean, theoretically, an agent could, not knowing that the letter hadn't been delivered, could on that basis continue engaging with an inquiry until after the time had passed for the revenue to correct it. So I would have thought all of those aspects suggest that the point you make, my lady, is a good one. So, as I say, that I think is when I say the background, that is what we say BDO did. And now I want to turn and look at why we say the Court of Appeal was in error in considering that there was no estoppel by convention in this particular case, or at least that this particular ingredient, the responsibility for the common assumption, is satisfied in this particular case. And the Court of Appeal appears to have been influenced by two particular points. The first, that it was the revenue that initiated the mistaken assumption by their letter to BDO enclosing the copy of the inquiry letter, so they misled BDO. And secondly, that in the Court of Appeal's view, BDO was simply assuming that what the revenue had said was true. And I say that that led the Court of Appeal to make 4 errors of law, and I'll deal with each of these in turn and develop our submissions on it. So the first error I say the Court of Appeal made was that the court placed far too much weight on the fact that the revenue initiated the assumption, and that the court unduly focused on the initiation of that assumption by the revenue without regard to BDO's subsequent actions, which reinforced and perpetuated the assumption the revenue had that an inquiry had been opened. And I think there are 3 points to be made on that. I'll then make good. First, it's no bar to an estoppel arising that the estoppel raiser was responsible for the initiation of the assumption. And secondly, what matters is the conduct of the party said to be estopped. Here, the conduct is what BDO said and did in response to the revenue's initiation of the assumption. And thirdly, on the facts, it's wrong to say, as the Court of Appeal did, that the mistaken assumption was induced by the revenue's misrepresentation or by any false statement. Now, my first 2 points, I say, are clear from the authorities, and there are 3 particular authorities that we just need to look at. The first is Amalgamated Investment, the second is Bench Dollar, and the third is a case called the Amazonia. And let me take you to each of those. The first, Amalgamated Investment, is at page 651 of the electronic bundle. And the brief facts here was that the plaintiffs were a property company registered in England to which the defendant bank had lent $3 million US dollars secured by mortgages on English properties. And the bank, the Texas Bank, agreed to make a further loan of $3.25 million US dollars to the plaintiff's subsidiary called ANPP, a company registered in the Bahamas. And that further loan was to be secured on property in the Bahamas, together with a guarantee from the plaintiffs. Now, the plaintiffs executed a guarantee in favour of the bank in respect of all monies due and owing to the bank by the plaintiff's subsidiary. But the loan was actually made through an intermediate company. So there was a company inserted between the bank and the borrowing entity, the borrowing subsidiary ANPP, a company called the name of Port Socan, and that was done for exchange control reasons which applied at this time. Nevertheless, the contemporaneous and future negotiations between the bank and the plaintiffs were conducted on the basis that the guarantee related to a loan to the plaintiff's subsidiary made the plaintiffs liable to the bank in respect of that loan. So the guarantee on its terms, although we'll see the Court of Appeal disagreed with Justice Robert Goff on this, the guarantee construed by Justice Robert Goff did not cover the loan that had been made through Port Socan. And the question was whether or not, because all the negotiations and subsequent discussions had been on the mistaken assumption that the guarantee did cover that, meant that the plaintiffs could not seek to avoid the liability. The plaintiffs had actually gone into insolvent liquidation, and the $3.25 million loan to the subsidiary was not repaid in full, and the plaintiffs' liquidators sought a declaration that they were not liable under the guarantee. The first instance judgment, as I say, was given by Justice Robert Goff, as he then was, and he sets out the 2 issues at page 656 in the report, letter H. He starts, and the 2 issues were the scope of the guarantee, and alternatively whether or not the plaintiffs are stopped from denying that they gave such a guarantee. And Justice Robert Goff concluded that the guarantee did not extend to the loan, but he accepted the estoppel argument, and he sets out 7 key findings of fact in his report. It's starting at page 666 of the report. If you go from letter E on that page, you can see he's setting out first, second, third. And in summary, the 7 points that he sets out is that first, that there was no sharp practice involved in any of this. The second is important, and you can see this at letter G, where he says, second, both the officers of the bank directly concerned, Mr. Nolan and Mr. Oldfield, believed at all material times that the plaintiff's guarantee was binding and effective and covered the liability of ANPP in respect of the Nassau loan, this was because they understood mistakenly that the money had been advanced by the bank to ANPP, whereas it had in fact been advanced by Port Soken. The source of their error lay in the bank itself. The mistake of both Mr. Nolan and Mr. Oldfield derived its origin not from anything said or done by any person acting on behalf of the plaintiffs, but from documents held by the bank or from persons within the bank. It's clearly the responsibility for the error lay with, for the initiation of the error lay with the bank. The third point at the bottom of that page is that officers of the plaintiffs also believed that the guarantee was binding and effective. And as regards the origin of that belief, you can see on page 667, in particular between letters B and C, that there was no evidence which persuades me to hold that Mr. Freeman's or Mr. Foster's mistaken belief derived from anything said or done on behalf of the bank. It's more probable that their mistaken belief had an origin independent of the bank, though after the question of securities to support the plaintiff's guarantee was raised by the bank in January 1975, the mistake of each, the bank and the plaintiffs, must have operated to reinforce the mistaken belief of the other. So the plaintiffs probably formed a mistaken belief independently, but thereafter each party's mistaken belief reinforced the mistaken belief of the other. The fourth on that page we see at letters just below letter C is that by their whole course of conduct, the plaintiffs, and in particular Mr. Foster, represented to the bank and encouraged the bank to believe that the plaintiff's guarantee was binding and effective. And the fifth at the bottom of page 667 is that although the bank's erroneous belief that the plaintiff's guarantee was so binding and effective originated in their own office, I'm satisfied that the plaintiff's course of conduct influenced the bank, and in particular Mr. Oldfield, in the sense that it operated to confirm and reinforce his mistaken belief. And over on page 668, we see the sixth, that encouraged by the conduct of the plaintiffs, the bank itself adopted a course of conduct which was detrimental to its interest. In particular, it allowed loans to remain outstanding despite opportunities to call them in. And seventh on that page is that if prior to the plaintiffs going into liquidation, the matter had come to light, the plaintiffs would immediately have arranged to have the matter put right. And we can note the parallels with the present case. So the party raising the estoppel, the bank, was the origin of the mistaken assumption. The party said to be estopped, the plaintiffs, through its conduct, operated to confirm and reinforce the estoppel raiser's mistaken belief. And the party raising the estoppel, encouraged by that conduct of the other party, adopted a course of conduct which was detrimental to its interest. So going back to what Justice Robert Goff said, on page 671 of the bundle, from letter E onwards, he makes various general observations about the law before turning to the facts on page 674. And then on page 674, at H, he noted that it was true that the source of the bank's error lay in its own administration, but he went on to note over the page at 675 around letter C that this did not matter because Mr. Foster's conduct, through of course though completely innocent, so influenced Mr. Oldfield's conduct as to render it unconscionable on the part of the plaintiffs now to take advantage of the bank's error. And on that basis, he continued on page 108, on page 675 around letter E, that by confirming the bank's erroneous belief that the guarantee was binding and effective and covered the Nassau loan, the plaintiffs contributed to the continuance of the bank's error as to the true legal effect, or rather the lack of legal effect of that document, and to the bank's failure to take the opportunity of putting matters right. So an estoppel arose, and he concluded that the plaintiffs were estopped. Now the plaintiffs appealed, and the bank cross-appealed on scope of the guarantee, and the Court of Appeal held that Justice Robert Goff had been wrong upon the scope of the guarantee, that it did in fact cover the debts in question, but nevertheless had been right on the estoppel issue. The first decision, the first judgment, was given by Lord Denning. We see at page 683 of the bundle, Lord Denning's judgment. And estoppel is first addressed at letter on page 687. At letter D, so we see the conduct. And we can see in particular just on that page, just above the heading course of dealing, as Lord Denning says, the judge put this telling point at page 108. Suppose the plaintiffs knew that the bank were under a mistake and did not tell the bank, but took advantage of it for their own benefit. Could the plaintiffs then take advantage of it? Clearly not. Then what difference does it make that the plaintiffs were under the same mistake? In other words, that was an innocent error on their part as well, but one which had been shared with the bank, so that they were both operating under a common mistaken assumption as to the scope of the guarantee. And then if we move on to page 688, and in particular what Lord Denning says, starting at paragraph C, letter C on that page, if the parties to a contract, and maybe my lords and my ladies, if you like to read from there where he starts, if parties to a contract, down to just below F, where he concludes with Crab and Arran District Council. And then, so we can see there that the focus is on whether the parties are bound by the conventional basis on which they conducted their affairs, where it would be inequitable to do otherwise, having regard to the way in which they've dealt as between themselves. And then just as we see Lord Denning's conclusion on the next page, so if you my lords and my ladies, to read on page 689 the conclusion that Lord Denning gives right until we get to Lord Justice Eveleigh. And as we can see, Lord Justice Evely gives the second judgment. The discussion of estoppel in his decision starts at page 692. And on page 693, we can pick it up around A to G on that page where he starts. Counsel for the bank referred us to a passage. And if we go down, if you care to go to the bottom of that page, we just see what he says there. And then the third judgment was given by Lord Justice Brandon. His comments on estoppel begins at page 696 of the bundle at letter E, but we can pick it up in particular on page 697 at letters E to F, where he says the two main arguments against the existence of an estoppel were advanced on behalf of plaintiffs, both for Robert Joffre and for us. First argument was that since the bank came to hold its mistaken belief in the first place as a result of its own error alone, and the plaintiffs had at most innocently acquiesced in that belief, which it also held, there was no representation by the plaintiffs to the bank on which an estoppel could be founded. Second argument was that in the present case, the bank was seeking to use estoppel not as a shield but as a sword, and that was something which the law of estoppel did not permit. The first argument, I say, in our respectful submission, is particularly relevant to the present case, which is precisely comparable, I would say. And Lord Justice Brandon dealt with it on page 697 of the report, where he says, I consider, this is just below F, I consider first the argument based on the origins of the bank's mistaken belief. And as he goes on to hold, going through page 698, the argument that the bank was at fault for the mistake and that the plaintiffs simply acquiesced in it had been deprived of any validity. In other words, it wasn't something that mattered because both parties assumed the truth of a certain state of affairs. Their transaction took place on that basis, and their course was influenced by it. And the fact that the assumption was initiated by the party seeking to raise the estoppel did not preclude it from doing so. And we say that that captures the situation in the present case. So what Lord Justice Brandon says about the first issue, we say is comparable to the revenue situation here, and captures precisely the way in which the estoppel arises here. The next case to take your lordships or ladyships to is the bench dollar case, which is at page 1227. And we have dealt with this case in some detail in our written case at paragraphs 38 to 43. And as we've said there, it's instructive to consider the correspondence that the revenue had written in those cases, which is set out at paragraphs 11 to 15 of the report. That's on page 1233 to 1234 of the bundle. The correspondence is actually set out at 11 to 15 on the following page. So in bench dollar, again, the mistaken assumption was initiated by the revenue, which stated that if the taxpayer wished to postpone the limitation period, the taxpayer could sign and return a form of acknowledgement, which was not in the event effective to achieve that. That was no bar to the estoppel. And at paragraph 53 on page 1244, the court held that there was a sufficient sharing of the common assumption. So as we see in the first line of that, applying all those principles to the present facts, I consider that first there was a sufficient sharing of the assumption. And then at 54, it was held that the employer assumed a sufficient degree of responsibility simply by virtue of returning the form. That's at paragraph 54 on 1244. So no suggestion that the fact that the revenue initiated the assumption or could be said to be at fault would be a bar, nor was there any suggestion that it would have been a problem if the employer had simply assumed that what the revenue had said in its letter was true. So bench dollar, we say again, supports the revenue's position in this case. And the third case, just to take you to, is the Amazonia, which is a paragraph page 769 of the electronic bundle. And this concerned a charter party which contained an arbitration clause that was void as a result of an Australian act to which the charter was subject. And the parties acted under a mistake of law in initially failing to realise that the Australian law governed the charter and that the arbitration clause was void. And acting under that mistake, they submitted a dispute to arbitration. Subsequently, after the close of proceedings in the arbitration, one of the parties sought to obtain a declaration that the submission to arbitration was void, and one of the issues was whether or not the plaintiffs were stopped by convention from denying the validity of the arbitration proceedings, and the Court of Appeal held that the plaintiffs were stopped. The first decision was given by Lord Justice Staunton, which is at page 779 of the bundle. And in the second column, we see he notes under the second paragraph that there was plainly a common assumption that there was a valid arbitration agreement. And over the page, at page 780, he said at the first paragraph of column 1, as to unconscionability, it does not seem to me significant who made the mistake, who had the better opportunity to ascertain the position. Then he adds in the second paragraph, it would, in my view, be monstrous if the owners were allowed to retreat from the position which they'd taken for over 4 years on the basis that the time limit under the Hague rules had expired, and therefore it was too late for the charterers to bring a claim in Australia, and the charterers had already incurred the costs of arbitration. In other words, the party raising the estoppel had acted to its detriment on the basis of a common assumption, because a time limit had expired, and it would be monstrous to allow the other party to resolve from that common assumption. Well, Justice Mann, who gave the second decision, did not address the estoppel issue. The third judge, Lord Justice Dillon, did so at page 784, the electronic bundle. And if we look at column 1, the third paragraph, beginning the modern formulation, you might care to read from there to the end of the second, so to the end of the first paragraph in the second column. So I said in relation to this first error of law by the Court of Appeal, I said there were 3 points to make in relation to that first error. The first being that it's no bar to an estoppel arising that the estoppel raiser was responsible for initiation of the assumption, and that secondly, what matters is the conduct of the party said to be estopped. Here, that conduct is what BDO said and did in response to the revenue's initiation of the assumption. And thirdly, I said on the facts, it's wrong to say, as the Court of Appeal did, that the mistaken assumption was induced by the revenue's misrepresentation or by any false statement. Those first 2 points, I say, are made good by the authorities that we've just seen. And specifically, in the light of those authorities, we submit that the Court of Appeal was in error in focusing on and placing too much weight on the fact that the revenue initiated the assumption. It failed to pay sufficient regard to the essential issue, which is the BDO's conduct in response to the revenue's initiation of the assumption. And as regards my third point, I say the court was plainly wrong on the facts to say that the revenue misrepresented matters to BDO and made a false statement. The first-tier tribunal concluded that the letter was delivered to Haybridge Lane, but was not forwarded to Mr. Tinkler. If it had been, we'd not be here today. It's not that Officer Mackay falsely represented to BDO that he'd written to Mr. Tinkler when he had not, or that he had sent the letter to Haybridge Lane in the hope or expectation that Mr. Tinkler would never receive it. Officer Mackay may not have been well enough to give evidence, but we do not have to assume that he acted with improper motives. Haybridge Lane was the address to which the inquiry letter for the previous tax year had been sent and was received in December 2004, even though Mr. Tinkler was in fact no longer resident there. And on the 1st of July 2005, Officer Mackay truthfully told BDO exactly what he'd done, and it was plain for BDO to see what he'd done. That takes me to the Court of Appeal's second error, which is that it's incorrect assessment of BDO's conduct. So the second error of law, I say, that the Court of Appeal wrongly formed the view that the validity of the inquiry was never referred to or considered in the communications between the parties, and the BDO never endorsed, affirmed, or addressed the truth or accuracy of the assumption that an inquiry had been validly opened. That's the written case at paragraph 55, at page 86 of the bundle. And I say this is incorrect as a matter of fact. And the error of law can be seen most clearly from what the Court of Appeal said in the second and third sentences of paragraph 65 of its judgment at page 160, where they talk about BDO proceeding on the reasonable assumption that what they've been told was true. And indeed, I can make this submission short because I've already taken you to the key correspondence with BDO. What the Court of Appeal says in the second and third sentences of paragraph 65 is simply wrong. We've set out in our written case at paragraph 55 the key material that the revenue rely upon to make good the submission, including what the revenue said in the letter of the 6th of July, including BDO's engagement with the Revenue's inquiry thereafter, including what was done at the end of October and indeed in November, to respond on the 24th of November to the Revenue's requests for information pursuant to its inquiry. That's at page 275. I don't think I've specifically taken you to that letter, but just so that you see it. It's the letter of the 24th of November 2005 that we see at page 275, which provided the response to the information requested. And you'll see that the first sentence apologizes for the delay in responding to your detailed inquiries. And the final sentence on page 276 notes that we trust that the above comments and supporting schedule answers your inquiries in full and await your further correspondence in due course. These communications are all within the time window for opening an inquiry. So the notion that the validity of the inquiry was never endorsed or affirmed or addressed or even referred to or considered in the communications is, we respectfully submit, unsustainable. That takes me to the third error of law by the Court of Appeal, that the Court of Appeal was wrongly influenced by its view that BDO had no reason to question the assumption that a valid inquiry had been opened and simply assumed that what the Revenue had said was correct. That's the written case at paragraphs 54 and 61 to 63 on pages 85 and 89 to 90 of the bundle. We say that's wrong for two reasons. First, it's not correct as a matter of fact that BDO had no reason to question the assumption that a valid inquiry had been opened. And secondly, in any event, it's no bar to an estoppel arising that the party said to be estopped has adopted the assumption as a result simply of assuming that what the estoppel raiser told him was true. As regards the first point, the Court of Appeal paid no regard at all to the fact that the Revenue had provided BDO with a letter that had been sent to Mr. Tinkler's Haybridge Lane address, showing the address. BDO knew that Mr. Tinkler's address was Station Road address, having prepared the return containing that address and providing the Revenue with Form 64-8 containing that address. BDO had access to their client, Mr. Tinkler, to check whether he'd received the notice, and BDO knew from October 2005 that the Haybridge Lane address was not Mr. Tinkler's correct address, as Mr. Tinkler accepted in his written case, as we've seen in paragraph 18. And of course, the first-tier tribunal concluded that BDO must have communicated with Mr. Tinkler or his PA in relation to the information the Revenue was seeking before they wrote to the Revenue on the 24th of November 2005. That's the first-tier tribunal's paragraph 51. So in our respectful submission, the Court of Appeal did not fairly characterise matters when it said that BDO had no reason to doubt the truth and accuracy of what the Revenue had said in their letter. They were at least as well placed as the Revenue to realise the error. Indeed, unless and until they were told otherwise, it's difficult to see how the Revenue would have had known that Mr. Tinkler had not received the inquiry letter, given the BDO's continued engagement with the Revenue and their request for information. And indeed, as regards the second point, even if BDO had no reason to question the assumption and had simply assumed that what the Revenue told them was true, that is not a bar to an estoppel arising, nor does it make it more difficult for an estoppel to arise. In a case such as this, it matters not how the assumption came to arise and whether the party to be estopped had formed the assumption as a result of what the estoppel raiser had said to it. The focus is whether there had been mutually manifest conduct, which demonstrates that the parties share the relevant view and whether the estopped party has played its part in the adoption of that common assumption. That's evident from bench dollar, where the assumption was initiated by the Revenue and adopted by the employers, presumably on the basis that they took at face value what the Revenue said. And it's also evident from other cases, such as Blindley Heath. Blindley Heath is at page 700, of the bundle. And you may wish to, I don't think we need read it now, but at paragraph 94 on page 723 of the bundle, we can see what the court says there to emphasize the point that it was sufficient to satisfy the assumption of responsibility requirement, that in the particular circumstances of that case, the estopped parties had, in effect, every reason to have been thinking in terms of company control and had every opportunity to raise the preemption rights and failed to do so, even though they'd both forgotten that such preemption rights actually existed. So that mutually manifested conduct, effectively the omission to raise the preemption rights in Blindley Heath, which demonstrated that the estopped parties shared the relevant view, and that was sufficient to give rise to the estoppel. And then the fourth and final error of law that I say the Court of Appeal fell into was that they appear to have considered that an estoppel can only arise where the party said to be estopped has positively assured the other party that he or she is operating on the same assumption and that he or she expects the estoppel raiser to rely on that. We can see that on page 116 in paragraph 66 of the Court of Appeal's decision, where they say at the bottom of the page, the revenue did not need or seek assurance from BDO that their assumption was correct, nor was any such assurance given. BDO neither said nor did anything to show that the assumption reflected its own understanding, rather than simply what had been told by the revenue. As a matter of fact, the correspondence simply belies that conclusion. BDO acted on the basis that a valid inquiry had been opened, and no doubt incurred costs for Mr. Tinkler in doing so. Why would that not reflect its own understanding of the position? Quite simply, it appears that the Court of Appeal considered that an estoppel could only have arisen if BDO had corresponded with the revenue along something like the following lines: you, the revenue, have made an assumption that an inquiry is validly open. That's our assumption too, and you, the revenue, may rely upon that. In his written case, Mr. Tinkler appears to contend that this is indeed what is required in order for an estoppel by convention to arise, where he suggests at paragraph 94 that the revenue were required to prove that BDO unambiguously represented to the revenue that the inquiry was valid. No authority is cited by Mr. Tinkler for this proposition, and in our submission it's wrong. It's no part of the Blindley Heath formulation of the ingredients, and it's clear from cases like Bench Dollar that this is not what is required in order for the assumption of responsibility ingredient to be present. What is required is simply that BDO said or did something which contributed to the adoption of the common assumption between the parties in such a way that it would be unconscionable for the revenue to rely upon it. And we deal with this further in our written case, as we say at paragraph 63.2, that the estoppel can arise where one party, the point is made by one party and acquiesced by the other. And Blindley Heath illustrates that. My lords, I see that we're at time for the short adjournment. I have finished essentially the point about assumption of responsibility. As I said, most of what I want to say about unconscionability in this particular case flows from what I've already shown you. If I may be permitted 10 minutes or so after the short adjournment, I can probably complete my submissions in that time.
Well, Mr. Gani, the timetable, I think, has you set down for finishing at 1 o'clock. But if you take 10 minutes into the afternoon, that will come off your reply time tomorrow morning.
Indeed, my lord. Yes.
Well, in that case, the court will now adjourn. Thank you.